Okay, this presentation will hopefully be useful to me later on as a study tool when I decide to get my credential in my home state. I live in the state of Oregon, the only state that has a two-sided flag. That is a beaver on the reverse side, and that is not a duck on the top of the slide. The state of Oregon has a panel called ORLA, the Oregon Educator Licensure Assessment Group, that puts together all the subject tests if you want to be a science teacher or a math teacher, and also puts together a civil rights test which every single teacher has to take and pass in order to be licensed in Oregon. And the goal is to have teachers who are competent and ethical, and who are culturally competent, who are sensitive to the needs of all of their students. So part of that test is understanding the legal framework which stands behind the principles that Oregon puts into place. I first want to give a shout out to Quizlet. This is an online program where you can create flashcards and study notes, and I found a Quizlet for the ORLA Civil Rights Test. I've had students in the past who have created Quizlets for my class and then sometimes revise them year after year, and it's a great way for students to work cooperatively. There's some fun little games as well as simple flashcards. So a lot of this is going to be quick and not a big deep dive, but it's enough to get me through my test and also to help you as well. I'll begin with some very broad principles. The First Amendment of the United States Constitution, 1791, has what's known as the Establishment Clause, that the United States is a secular nation. It welcomes all religions, but that it is wrong for the government to try to establish one type of religion. And there are some Americans who don't really like that, but that's the way it goes. The 14th Amendment, coming after the Civil War, established rules about citizenship, including the idea that you didn't have to be white to be a citizen of the United States, and also the idea that if you were born in the United States, then that granted automatic citizenship and all the rights that go with that. Unfortunately, the 14th Amendment didn't do anything for gender, so even though it gave, after the Civil War, the right of blacks to vote, it did not empower women to vote, which we will talk about later. The McKinney-Vento Act is an important federal law that was passed in 1987. It's about homelessness in general, but specifically in Oregon and the United States in general, there are obligations of school districts to meet the needs of homeless students. So again, the First Amendment, this idea that the United States is not trying to establish one religion, but that we are all equal under the law. The idea that citizenship is something that is not restricted only to people of a certain race. And my graphic for homelessness shows a person couch surfing. We have this idea that homelessness is about living on the streets and in tents. And in the case of Oregon especially, there are thousands of homeless students, and they are sleeping on other people's couches, and they don't have permanent stable housing, which limits their ability to be good students. So there are programs in place that if you are homeless, the school district is required to provide transportation for you to your home school district, even if you go live with an aunt who lives 20 miles away. So Oregon's Bill of Rights is huge, and it's based on the Bill of Rights of the United States Constitution. I would note the natural rights inherent in all people, which we are still fleshing out in the year 2019. A lot of things related to religion. Oregon is known as a non-church state, and that's there's lots of statutes related to that. Oregon recognizes the freedom of speech and press. And then there's a lot of things about crimes and jury trials and things like that. Things about quartering soldiers, things about taxes and duty, selling liquor by the individual glass. In Oregon, you have to go to a state-owned liquor store, by the way, if you want to buy distilled alcohol. But I want to slide on down to the bottom of the list, prohibition on denial or abridgment of rights on account of sex. This does not, at this point, specify sexual orientation or gender identity or things like that, although those are ideas that the state of Oregon actively promotes through its education programs. Some important court cases over the years. There was a case in 1943. A school district tried to fire a bus driver because he was too old, and the court case decided that you could let people continue to serve as bus drivers. The man on the right here is 90 years old. At the time the picture was taken, he was the oldest bus driver in North America. In 1943, and actually in the years before 1943, the ramp up to World War II, there was a very nationalistic fervor, and you were required to say the Pledge of Allegiance. And if you did not say the Pledge of Allegiance, then you could be kicked out of school, and then you could be held truant. By the way, the students here are doing what's called the Bellamy Salute, which was a very, very popular way to salute the flag before World War II, obviously, and that has since changed. There was one group that was especially harmed by this, and that was Jehovah's Witnesses. And there was a lot of discrimination against Jehovah's Witnesses. Their churches were burned down. And the Supreme Court said, you do not have to salute the flag in school. So, again, Childers versus Morgan was about employees of schools, and you couldn't force them to retire. West Virginia versus Barnett was about saluting the flag. And then really, really important, Brown versus Board of Education of Topeka, Kansas. The post-Reconstruction era, or the Reconstruction era after the Civil War, there was a famous court case called Plessy versus Ferguson that said, you can keep blacks and whites separate as long as you have, equal facilities for each of them, and that included things like drinking fountains, which obviously these are not equal for white and colored. And in 1954, the important Supreme Court Brown versus Board of Education said that we have black schools and we have white schools, and by and large the white schools are better, and we need to give students of all colors the chance to have an equal education. And so Brown versus Board of Education brought in the idea that schools had to be open, and then pushing that further was the idea that school districts had to actively move students from place to place. They had to bus them from place to place so that they could access the better schools, since by and large the schools in black or minority areas were inferior to those in white or the dominant culture areas. A few more things to keep in mind. There's a lot of titles. Title VI of the Civil Rights Act is all about how you can't discriminate against people on the basis of color or national origin. Title IX, people often refer to in the United States, is the idea that you can't discriminate on the basis of sex. And a lot of college sports programs fall into Title IX funding, that you can't have a lot of funding for your football team and not fund women's sports. So Title IX is often mentioned just as Title IX. No Child Left Behind Act under George Bush had a Title III, which said that you had to be equal in how you address students who were limited in their ability to speak English. So if you had students who were native Spanish speakers or native Mandarin speakers or whatever else, you could not discriminate against them and had to meet their needs. The Americans with Disabilities Act, Title II, is the idea that people with different physical disabilities need to be treated well or equally in the education system. And the IDEA is Individuals with Disabilities Education Act, which said that schools need to make specific plans to deal with students who have different impediments to their learning. The Rehabilitation Act of 1973 excuse me, has to do with employment. So that would apply more towards school employees who need to have the ability to have accommodations in their work. And Section 504 is something people have a 504 plan that's addressing, again, students with disabilities. And Oregon specifically has statutes under ORS 659. Apparently, as an Oregon teacher, I need to learn that number at some point. Throw out a few more things for you. Hobson versus Hansen, the school district was tracking students, and there seemed to be racial discrimination. That court case also involved some busing issues. Tinker v. Des Moines was about students who were protesting the Vietnam War, and they went to the Supreme Court that they needed to have the right to have free speech, and their right to advocate against the Vietnam War was upheld. Swan versus Charlotte-Mecklenburg, a South Carolina school district, was again about school busing and racial integration and the need for them to devise a better plan than they had in place because otherwise their policies were racist. Lemon versus Kurtzman is really interesting. The idea that the federal government sometimes gives money to religious schools. And Lemon v. Kurtzman decision was about how there needs to be a clear separation between church and state. There have been more recent cases, however, where there's a private school that's a religious school, and there might be federal funding which allows to build a playground, and that playground is open to all children on afternoons and weekends and throughout the summer. And so sometimes religious schools can receive funding if it is for an overall public benefit. But again, the separation of church and state, that you can't have the state funding religious schools. And then Lau versus Nichols was about students not being able to access education because they were Chinese speaking, and the case upheld the right of students to receive an adequate education even if they're not native English speakers. And I think that's all I have time for. Oh, a couple more. VMI was a military school that received a lot of federal funding, and in 1996 it was integrated, and women were able to attend VMI. That if the federal government is funding it, then they need to let women in. Board of Education versus Rowley was one in which a student was deaf and the parents were advocating that they had to have a sign language interpreter. And in that case, the Supreme Court actually said, no, they need to have equal access to education, but there are limits on that. So in the case of the student, having an individual sign language interpreter was not enough. The Hazelwood School District versus Kohlmeyer was a paper in which students had written some articles about divorce and teen pregnancy, and the advisor said, you can't write articles about that, and they said, we have the right to free speech. And in that case, the Supreme Court said, no, you don't have the right to unlimited free speech. If you are expressing a personal opinion, that's fine, but if you're in a school paper, it is permissible for the school to limit your free speech. And then Harper v. Poway was a student who showed up to school with a homophobic shirt and argued that he had the right to free speech. And the Supreme Court in that case as well said free speech is not permitted if it is harmful. So obviously students who are homosexual would be greatly offended, and it would lead to a hostile school environment. So a lot of different cases and a lot of different principles at work, but the idea that everyone has access to education is important, and still the United States struggles to overcome issues of race and discrimination on account of a lot of factors, but we're improving.